So our victory over tribunal fees in the Supreme Court was not just a victory for Unison and its members, it was a victory for all workers in Britain, and shows what can be achieved when we all work together as a group. And as Punima mentioned, only a union could have taken this case because we funded our members' claims. However, what we wanted to do was to attack the principle at stake here. And there were extremely important principles at stake, and restoring access to justice for all workers was a dream we had, which I'm pleased to say was achieved. So I was asked to talk briefly about how we ran the case. And, oh, I have to go over here for one slide. Sorry, I apologize. Oh, that's why. No, that's fine. That's fine. Thanks. And for that, we need to go back to January 2011, when Chris Grayling first announced the government's intention to introduce fees in the ETs and the EATs. Now, various eminent people responded to the various consultations that followed, and we did as well, but we were all largely ignored, and it was clear that the fees order was on its way. When we first sent our letter before claim back in May 2013, we didn't think it would take 7 hearings and 4.5 years to actually get to this point. In the beginning, the Lord Chancellor didn't engage with us at all, and our claim was in any event dismissed on the papers in court, and we needed to ask for an oral permission hearing. Now, sorry, I'm going to make sure this works. Yeah, it does work. Now, when fees were introduced, as you know, most of you will know, you couldn't bring a claim until you lodged this fee or you got remission for your help with fees for your case. And fees ranged from £160 to lodge the claim to £250 to lodge the claim, and then you had a further hearing fee of £230 or £950. And if you went to appeal, it cost you £1,600. So we're talking about people who are, low value claims. Sometimes, you haven't been paid your wages, £100, £200, and you have to go and pay £160 to try and exercise your rights in tribunal. If your case wasn't accompanied with a fee or the very long form you had to fill out for help with fees, then your case was dismissed, it was kicked out. There was this help with fees scheme, suggests that it targeted people who were on low wages. Unfortunately, it didn't. If you were on national minimum wage, you still couldn't get help with fee in certain circumstances. Anyway, we had our permission hearing, and it was on the same day that fees were introduced, and it was quite surreal, really, that we were trying to say to the judge there, perhaps we can stay these proceedings, try and resolve the issue first before you introduce the fee scheme to see what happens. And the judge said no, the fee scheme goes ahead. However, the Lord Chancellor at that point gave an undertaking that he would refund fees should we win, which was a very helpful undertaking. At the time, I don't think he believed that it would come to that. Now, the first judicial review hearing was extremely hard to bring. We identified hypothetical claimants using Joseph Rowntree information. We tried to, I put in freedom of information requests to the government to ask whether fees had an impact on claims. And in the beginning, they weren't willing to engage with us again. When they eventually had to concede to us and produce these stats before the quarterly reports were due out, it already showed within about 6 weeks that there had been a 56% drop in claims. Now, the first claim was heard by Lord Justice Moses, and it ran for over 3 days. And we argued several things. We argued that the fees regime breached the EU principle of effectiveness and equivalence, that it was indirectly discriminatory, and we used women as our example, but we could have used any group, really, because it had impacted all the strands, equality strands. And we also argued that it breached the public sector equality duty. Now, when we got to court, when we finally got a judgment in 2014, the High Court dismissed the claim because it said our arguments were premature because we only had this one lot of statistics. So, should we have waited? Well, I'm sure if we had done, we would have been told we were out of time. And by the time the first judicial review had ended, we had more statistics. And here, you know, we could show that there was, a 90% drop in sex discrimination claims, for example, 75% drop in equal pay claims, etc. So we lodged our appeal, which was described as striking, that it wasn't enough. And we were given permission to appeal to the Court of Appeal at this point. Now we're in the Court of Appeal with both appeals now from both High Court judgments. And here, the Lord Justice Underhill said, despite this case being seen as troubling, and despite there being a strong suspicion that so large a decline in claims is unlikely to be accounted for entirely by cases of won't pay, it must also reflect at least some cases of can't pay. They still weren't willing to take us over the line. And Underhill's view was that we needed to show actual individuals who couldn't afford the fees. Now, we didn't want to go down that line because we didn't want the newspapers sort of scrutinising individuals who claimed that, I couldn't afford the fees because I had to buy my kids shoes, or I had to, I went out for a meal yesterday. We didn't want individuals to be scrutinised in that way because that wasn't the point. This was a case about access to justice. So we held our line, and we didn't introduce an individual claimant, and the Court of Appeal didn't give us permission to appeal to the Supreme Court. We tried again, and we got permission. Now, in the meantime, I, along with several others, gave evidence to the Justice Select Committee about ET fees. And the report from the Justice Select Committee concluded that fees were too high. That's no great thing, really, because everyone knew it. But then, and it also said that rather than putting off vexatious claimants, which is what the government was trying to achieve, it was actually putting off meritorious claimants. And the reason they came to that conclusion was because of evidence we had all given that success rates were going down. Now, you would imagine if fees were meant to put off all these bad claims, success rates would increase, but they weren't. They were going down. Meritorious claimants were being put off. So when we got to the Supreme Court and argued that there was a lack of effective remedy under common law and EU law, so what we decided to do was look at common law in light of the impending Brexit, and that women in particular were being indirectly discriminated against. We also argued that there were flaws in the remission system, that there was an impact on low-paid workers particularly, because all those unlawful deduction of wages claims were disappearing. And all those, people who hadn't had their statement of terms and conditions, people who were on national minimum wage, those cases weren't there anymore. And the other thing that we said was that the government, in their equality impact assessment, had said that there was no social impact of fees on workers, that the impact was nil. For them to actually say that, it's quite incredible. It was in a little footnote somewhere in the equality impact assessment. And that really rung with some of the Supreme Court judges who found it incredible when they asked the Lord Chancellor's barrister, what is your view on this particular point? And they just had no view. They just said, well, there was no impact. Said, what about the welfare state? Well, it has a knock-on effect when people go out of work and cannot challenge their employers. Anyway, we repeated all our stuff. The claims have gone down at this point on average by 70%, and in some cases much greater, and that success rates have improved and indeed have declined. So this time we were lucky, and I think timing was everything for us. And if it hadn't been for the Article 50 decision and the review outcome and the general audacity of the Lord Chancellor and their viewpoint, I suspect that it also came together when we got to the Supreme Court. So what next? Or who did bring their claims and were charged a fee or kicked out because they couldn't afford the fee. Now that's very clear, and you can. The forms are quite onerous, but if you belong to a trade union, the trade unions are doing it for the individuals. But any individual who couldn't afford the fee can go back and fill out this form now and get their fee back. Also, there is the situation that there would have been many people who wouldn't have felt able to bring their claims. And those people can now write to the tribunals and say, look, I was put off bringing my claim because of fees. it'll be a very difficult thing to do right now, 4 years after the event. You know, the employer might have gone bust, who knows? But it's still worth a go, and there will be plenty of litigation around it. But I hope you encourage people who you meet who may have had a claim to bring at some point in their lives during the fee regime, but felt they were unable to do so, to encourage them to actually bring those claims, because it's better now than never.